national laws that recognize access to information. And now there are over 80 laws on access to information around the world, a number of which are in Africa, including a growing number. And it's increasingly recognized in constitutions, in laws, and in international instruments. If you flip to the next slide, which covers key principles of the right to information. One of the most important key principles of the right to information is the idea that there is a presumptive right to access information. The idea that disclosure is the norm and the exceptions are limited, and limited exceptions must be established in law and justified. Access to information will apply to public bodies, information that's held by public bodies, but also, and increasingly, and we're seeing this even more in some of the new laws in Africa, more so than it is seen in some of the laws around the world as well, although it comes up in practice and judicial decisions around the world. Access to information applies not just to public bodies, but also to private bodies that are performing public functions, or as is true in the South African law and in the model law for Africa, which is now in draft form, hopefully pending future approval, where information is necessary for the exercise or protection of a right. There are principles that the right to information will be free or low cost and be accessible. And that obviously will mean different things with different populations that are dependent on the access to information. The information should be available to all citizens. And I referenced in the overview slide that I was going to speak about proactive disclosure. I think probably everyone is quite aware of the distinction, but I think it's a critically important distinction with access to leaked information between reactive disclosure, which is what people often think of, and proactive disclosure. People often think of reactive disclosure when you're talking about right to information laws, where an individual has a right to make a request for information from the government or from a private body in certain circumstances, as referenced. And if there is a denial of that information, a right to appeal the denial of that information, where proactive disclosure references the obligation to publish the information, and obviously a lesser obligation does not necessarily apply to all public information or all relevant private information, but we'll reference some of the areas where proactive disclosure applies in core categories of information and how that would be applicable within the context of access to legal information. I'll flip briefly the next slide on right to information matters, in part because I think it has been referenced by some of the other speakers. But access to information is obviously critically important for a variety of different reasons, three of which I wanted to highlight. The requirement of information to facilitate public engagement in decision-making, the requirement of access to information for the preservation and protection of fundamental rights, and for access to government services. And as has definitely been referenced already in the early minutes of this meeting, for accountability of public institutions and the legitimacy of those institutions. So I mentioned the dramatic growth that we've seen on slide, please. I've mentioned the dramatic growth that we've seen in access to information law practice around the world. That is definitely true in Africa as well. We've seen a growth of right to information laws and constitutional protections, and an increasing recognition of the international institutions that support and identify access to information as a fundamental right, and the growth of and acceptance of right to information in African, regional, and continental institutions. So I'm going to go very briefly through what some of these are in the African context: constitutional rights to information, statutory rights to information, including all-encompassing right to information law, also RTI provisions, and mentioned policy and practice just highlight some of the international. I'm hearing an echo. I don't know. If you just nod, Maria, I'll know that you're okay, and I'll keep going despite the echo. It's okay? Okay. So within the instruments of the African Union, Article 9(1) of the African Charter recognizes that every individual shall have the right to receive information. Article 19 of the African Charter on Democracy, Elections, and Good Governance makes a similar recognition. The African Convention on Preventing and Combating Corruption also recognizes the importance of access to information for challenging corruption. There is a critically important role in Africa for the Special Rapporteur on freedom of expression and access to information. And as a sign of the growing recognition of access to information within the African continent and within the institutions, in 2007, the Special Rapporteur's position, Advocate Pansy Lakula, was expanded to include not just freedom of expression, but also access to information. Next slide, please. The Declaration of Principles on Freedom of Expression in Africa was produced in 2002. The African Commission. Article 4 of this declaration includes specifically right to information, and these are the quotes pulled directly from the declaration, which you'll see cover and address some of the principles and are aligned with some of the principles that I highlighted initially. The first being essentially presumptive disclosure, the default of openness rather than of secrecy, and the requirement that there are clearly defined rules established by law wherever secrecy will be held to be warranted rather than the presumptive disclosure. Principle 2 recognizes that, is there a problem? Okay, Principle 2 recognizes that right to information will be held by public bodies and private bodies where necessary for the exercise or protection of any right, that there's a right to appeal, a duty to publish, no sanction for public officials who release information in good faith, and no sanction for the release of information that is regarding wrongdoing. So essentially a recognition that there should be some sort of whistleblower protections. And the recognition that that might mean and should mean in a number of circumstances amendments to existing laws in Africa, in African nations, certain nations that have a presumption of secrecy for public information. So the next slide, I just highlighted some of the international instruments that are most critical here. Article 19 of the Universal Declaration of Human Rights, Article 19 of the International Covenant on Civil and Political Rights, and the UN Convention on Corruption. Next slide, please. I'm not going to go through all of the constitutional protections and legal protections that exist in Africa, but I just wanted to highlight them in part to show the dramatic growth of them. There are 33 countries with one form of constitutional protection of the right to information in Africa, 16 countries with an explicit recognition of right to information within the Constitution and then listed there. And the next slide, an additional 17 countries that recognize within the Constitution right to freedom of expression, and included within that a limited right to receive information. So not as expansive as the prior set of countries, but still an important constitutional recognition and constitutional grounding for the right to information. Next slide, please. There are 10 countries that identify, though there are some different counts by different people, but 10 countries with differing levels of protection of right to information laws in Africa. You'll note that there are 4 countries, Guinea, Liberia, Niger, and Nigeria, that have developed and passed and enacted and are in the process of ensuring implementation of right to information laws in the last 2 years. So the clear sign of the quite significant growth. Next slide, please. One important thing to highlight is that there is often a strong push for all-encompassing right to information laws. In the Nigerian context, where the law is one of the most recent, that was a 10-year push. And that will probably be a similarly long push in a number of the countries that do not yet have access to information laws. It certainly can be a challenge to enact them, but there's an important recognition that even in countries that don't have all-encompassing access to information laws, there are access to information provisions that exist within other laws, such as archives laws, evidence and administrative codes, civil procedure codes, anti-corruption laws, particular sectoral laws, such as related to health, environment, and extractive industries, budget monitoring, and at the subnational level, so in provinces, localities, or regions. Next slide, please. One really important development for access to information on the continent is a process that's been ongoing over the last year and a half to develop a model law for Africa. There was also a model law for Latin America that was developed about a decade ago and has been really instrumental in pushing for new and progressive access to information laws in Latin America. There was a strong belief by many working on access to information on the continent that a similar process in different regions in Africa would be really useful as well. So under the leadership of Advocate Penzi Lakula, the Special Rapporteur, there have been regional consultations in Southern Africa, West Africa, East Africa, and North Africa, and there are ongoing discussions that hopefully will be recognition of this document for the strength that it is at this point. And Maria will have access through the slide presentation, as well as others may already have access and have been present at some of these meetings, to the online version of that, which is available in a variety of different languages. So I encourage people to look at it if you haven't seen it yet. So next slide, please. Coming to a close, and I'm going to highlight mostly towards the end of this, the proactive disclosure component of this, because I think it's critically important when we're talking about access to judicial information and the link with right to information principles. Often when we're talking about right to information law, we are mostly speaking about reactive disclosure. Proactive disclosure is critically important, especially when speaking about fundamental government functioning and laws, and also in contexts where the members of the public have extraordinarily limited financial resources. Reactive disclosure requires a certain amount of knowledge about what the laws and processes are, and if there is a denial of information after a request, it requires sometimes, in some cases, and in most cases where there's not information commission, which is true in most countries in Africa, it requires a lawyer to be able to mitigate the denial, which is obviously a tremendous burden, particularly for the average citizen or member of the public in most of the countries in Africa. Some of the important foundational principles of proactive disclosure, the recognition of the importance of access to information disclosed proactively, both for the public and also for the public bodies themselves, for greater efficiency from the bodies, for greater understanding from those who operate within those bodies of the value of the way that the bodies function, and for the legitimacy of those bodies within the broader society. Proactive disclosure improves the reliability and accuracy of information as it's disclosed automatically, and usually, if done correctly, close to the time of the production of the information. It allows for anonymous access. So, if the information is made available in a way that the general public can access, it doesn't require someone to say, I want this information and it should be provided to me. It also reduces the burden on the government actors who would otherwise be reading and responding to specific requests for information. And it leads to a greater equality of access to information, where information is not held primarily by the individuals who are making the requests for information. I think Advocate Tererai, if I remember correctly, spoke about recognition by business leaders that access to information is really important for them to understand what the benefits are for different business actors. And that's one of the things that is often found around the world is that business actors rely on information access and right to information laws quite significantly. Obviously, they have greater resources than many of the members of the public. Things available to some with more resources should be, information that's available to some with more resources should also be made available to the general public as well. Next slide covers the principles of proactive disclosure. Some of these are drawn from a document by Helen Derbyshire on proactive transparency that was produced as part of a World Bank Institute independent document, not a World Bank document, but from a governance series where they produce these documents on key issues, including around right to information. The information should be available. It should also be findable for those who should have access to it, so findable to the general public. Should be relevant, accurate, comprehensible, so in a manner that's accessible to the population. So, you know, when we're talking about data, for instance, not just a database dump, that's not the kind of information that the public can generally access. Free or low cost and up to date, which is similar to it being accurate. Next slide. I'm not going to go through all of the core categories of proactive disclosure because I think it's more important to highlight the core categories of proactive disclosure in the context of legal information, but I highlight them here, and I would just highlight in particular decisions and acts and decision-making, information related to decision-making and public participation. You could flip to the next slide on proactive disclosure in the judiciary. You know, I think some of the general principles that I highlighted or the general reasons why proactive disclosure is important for government functioning are obviously applicable and transferable to the judiciary, to the context of the judiciary and legal information. But some are especially true for the judiciary and especially true for legal information and bear greater elaboration. For public oversight of the functioning of the judiciary and recognition of the importance of both objectivity and perceived objectivity of the judiciary. That's critical both because it lessens discretion and corruption possibilities, but also because it increases public support for the functions of the judiciary. As is highlighted, the importance of judicial reasoning for a broad sector of society, the general public, including lawyers, but also the lower courts. If a constitutional court or Supreme Court decision is not available to the lower courts, it's more difficult to know what the judicial reasoning is that courts should follow. And the principle of the rule of law requires that general laws, and their enforcement are known. This would apply also for the interpretation of laws by the judiciary. And as highlighted previously, there's the value internally within the judiciary or within an individual law for greater efficiency and greater information management and sharing. To come to a close, I just wanted to highlight some of the core categories of judicial information that have been recognized, and I'm sure that there will be more that will be discussed over the course of this meeting as well. But a website should be available with basic information regarding courts, and I just did a quick review of the websites of the courts, of the regional courts and the continental court, and they're certainly quite strong websites providing at least the most basic information about the courts, and in some cases quite a significant amount more. The rules and regulations, statistics on cases that are filed, that are resolved, and that are pending, the agenda of the courts, budget, salaries, and the backgrounds of relevant officials, bidding and procurement information for a contract, and judicial decisions. So the last key slide, and then there's a couple of other slides which I basically just pulled together as information that's available for you all, websites, more information if desirable. But there's a famous judicial decision in the UK that has been cited all around the world on the theme of open justice that says that justice should not only be done, it must also be seen to be done. And I think that that's a critical driving principle here and really governs the idea and the importance of access to legal information, both within the judicial system and more broadly. I will also highlight that as one of the resources that's available, we produced at the Justice Initiative a website called right2info.org with the number 2, which includes a database of on access to information around the world. And we are revising the database, but I highlight it for 2 reasons. One, to make it known to people, but also as a sign that there's a clear recognition of the difficulty of trying to get all of this information available publicly. We struggle to pull all of this information together to make it in a form that's accessible to those who we presume would want to use this information and to keep it up to date. And so we share the challenges that all of you are facing in this as well, although at a lower level and with a lesser quantity of information, and I would say probably also a lesser obligation to the broader public. And I don't want to be presumptuous about the way forward not being room there, but I'm certainly hopeful that there will be a really strong way forward and cognizant of the fact that there's leadership that to make a really strong way forward possible. And I think the demonstration of what has already happened in the Seychelles is a real sign of how leadership and political commitment can really transform access to legal information for the broader public. So thank you very, very much. It's really a pleasure and an honor to be here with you all in the limited way that I
am. Advocate Terai Mafukitse holds a Bachelor of Laws Honours LLB from the University of Zimbabwe, which was awarded in 1996. He is due to complete his Master's in Law, in Corporate Law with the University of Witwatersrand. He is majoring in Competition Law, Banking and Finance and Company Law. He was admitted as a legal practitioner, notary public, and conveyancer in the High Court of Zimbabwe in February 1997. He practiced law in private law firms in Bulawayo, Calderwood, Bryce, Henry and Partners, and Harare, Scanlan and Holderness for 3 years before he joined Old Mutual as legal advisor. He joined the trust group as listed financial services company as legal manager of the trust bank. He became group company secretary in April 2005. He left trust in October 2006 and moved to South Africa to take up a position with the Constitutional Court Trust of South Africa as the coordinator secretary of the Southern African Judges Commission, lately known as Southern Africa Chief Justices Forum. He subsequently combined this responsibility with the directorship of the Southern African He subsequently combined this responsibility with the directorship of Southern African Legal Information Institute, SAFLI. Mr. Terai left the employ of the Constitutional Court Trust at the end of March 2010. He works for the African Legal Information Institute. He is involved in the establishment of legal information institutes across the continent. He has attended and spoken at many international and regional conferences on free access to law, constitutional law, judicial independence, human rights, and corporate law. Ladies and gentlemen, let us welcome Mr. Terai Mafokitse.
Good morning, Honorable Chief Justice, Justice Mukandawire, ladies and gentlemen. It is a pleasure to welcome you to Johannesburg. To this important event that discusses access to African supranational courts and regional law. In my discussion with you, I'd like to focus on how African courts can participate in this initiative to bring African law freely and make it freely accessible to citizens of our different countries, to practitioners, and to judges.